Welcome to SOS for Your Life, Emergency Wisdom for Everyday Life. I'm your host, Susie St. Angelo, and thank you for being here today. Today's episode is called Estate Planning, Not Just for the Wealthy. My guest today is Ellen Deeter, an attorney in Indianapolis, Indiana. Ellen has spent most of the past 35 years working in bank trust departments. She's a graduate of the University of Notre Dame and the Indiana University Robert H. McKinney School of Law. I think you'll really enjoy and get a lot of useful information from our conversation. You know, this podcast is for you if you know you want to change something. Maybe it's your career, maybe it's your health or another aspect of your life. And you might wonder if this is the right age or stage in life to make this change. And you just don't know where to start. Well, you've come to the right place. You can always find a step or two or a tidbit of information that will help you make that next small step. Or maybe you're that person who's caught in analysis paralysis. I understand. I used to feel the same way. But just to know that you can do it. And just a reminder, you can find this podcast on Spotify, YouTube, iHeart, Apple, and Amazon platforms. Remember to like, share, and subscribe. Now let's get into today's episode and meet my guest, Ellen Deeter. Hi, Ellen.
Hey, Susan.
How are you today?
I'm great.
Good. I'm so thrilled to have you because I feel like estate planning is one of those conversations that people don't necessarily want to have. Maybe they need to have. And as we said before we went on, sometimes the terminology and the term estate planning can give glassed over eyes and people get really nervous about talking about it. So I'm excited for you to share your wisdom with everyone. And I guess my first question is, tell our listeners and viewers about yourself and what inspired you to become an estate attorney.
Okay, well, to be totally honest, a little bit was by accident. I went to law school, not necessarily thinking about what area I would practice in, and I got a job auditing inheritance tax returns for the Indiana Department of Revenue. And what I discovered with that job is I really liked trusts, tax, and estates. And the thing that I like about practicing in this area is I think of estate planning as preventative law. You think about preventative medicine. What are the steps that you can take to remain healthy? With estate planning, it's what are the steps that you can take, one, to provide for yourself in the event something happens to you, a medical injury or something like that. And secondly, how do you prepare for your passing and the distribution of your assets to your loved ones in a way that's efficient and accomplishes your personal goals? Frequently we talk about taxes in connection with estate planning, but it's really more about what your values are and who are the people that you love that you want to take care of.
Can you explain what your role is as an estate attorney?
When I meet with clients, I try to help them, first of all, define who it is that they want to benefit and who they trust to help make decisions for them in the event that they're unable to. So part of it is looking at their assets, but a great deal of it is looking at who your family structure is. And when I say family, I don't necessarily mean blood relations, because not everyone is married, and not everyone who is married or has children necessarily has a great relationship with them. In an ideal world, that's the case, but not everyone has that. So part of what we're doing is helping clients define and clarify in their own mind who it is they want to benefit, and who it is they want to take care of them. So estate planning is a little bit of a misnomer because we typically think of it as doing a will that passes my assets at death. But the other documents that I typically do for my clients involve documents that affect their lifetime. One is a general durable power of attorney. If you are unable to make financial decisions for yourself because you're incapacitated, this document allows someone to step in and handle your financial affairs. Open bank accounts, write checks, sign your tax returns, have your tax returns prepared, financial decisions. The second document, which is actually now a combination of two documents we used to use, is called the Advance Directive. Now, prior to a couple of years ago, that was typically broken down into the appointment of a healthcare representative and a living will. Now you can do all of those things in one document called the Advance Directive. So the first part of that document is, if I am unable to make medical decisions for myself, who do I want to have speak for me? Who can tell the doctors what to do? If I'm in a coma or I've had a stroke or something disastrous has happened medically where I can't speak for myself. The second part of the document has to do with end-of-life decisions. If I am in a persistent vegetative state, and again, I'm in the end stages of my life, what kind of care do I want? Do I want artificial nutrition and hydration? Or do I not want that? Or am I unable to make a decision and I'm going to leave it in the hands of my healthcare representative? And those decisions mostly revolve around the administration of nutrition and hydration. One thing I want to point out is even if you say in your advance directive, I do not want artificial nutrition and hydration, you still are going to get pain relief. I think that many people are very concerned about that aspect of the dying process. So again, it's the kind of thing that you need to think about ahead of time. And so in between those two stages, there are also things that you can put into your advance directive that expand on what it is you want. You can put into that document, for example, that you prefer to remain at home, if at all possible, even if it costs more money than going into a healthcare facility. Now, obviously, there are going to be times when that simply is not possible. The level of care is too high and it can't be provided in an in-home setting. But you can still express your wishes and goals about that in terms of your first choice is, if at all possible, I want to stay in my own home, because home offers comfort and familiarity. So that's one of the things you can put in there. Although I haven't done it in any of the ones I've written, you can put in there, if I'm in the dying process, I want this kind of music played. You know, they say that hearing is one of the last of your senses to leave you when you are in that process of leaving this world. And so I remember a client very distinctly who, when she was dying, her children played 1940s big band music because that was the music she grew up with and she loved. And so, again, some things that provide comfort are part of the care process. So you can include that in your document if you want.
So, I love hearing that example because that is love that the person has, or that the person who's taking care of the advance is a part of the advanced directive is asked to step up and take care of. And I love that. And I want to cite just another example. When I had my little financial services business, I was hired by a woman who had just been diagnosed with early Alzheimer's, and they were going on a trip around the world on the QE2. And so she had a meeting with, she called it her board of directors. And it was her estate attorney, her power of attorney, me, her trust officer, her sister, her husband. They didn't have kids of their own. They didn't have any kids. They were in their 70s. And I was so impressed at how organized she was. And like you mentioned, she had every decision and every planning step done down to what she wanted to listen to if she were in hospice or dying, and how relieved she felt knowing that, one, she had the right team of people around her, but she also, had stated what her wishes were.
Yes. Yes.
And I just will always remember, respect, and appreciate what work she did ahead of time.
Yes. And that is a gift. One of the things I tell clients is when you have a plan in place and you've made these decisions, you are giving a gift to your family members and your loved ones, because they're not wondering and second guessing themselves. What would mom want? What would dad want? Because you've thought about it. And I encourage people, once they've made those kinds of decisions, to talk about it with their loved ones ahead of time. It's not an easy conversation to do. And a lot of people aren't ready to, because, it's just a very private matter, especially if it also flows into what their documents say about who gets what when they pass away. But you can have decisions about end of life stages and what you want without necessarily disclosing your financial assets and things like that.
I think that's really critical. I know I've done that, and I know someone I was close with did that with their children after the estate plan was updated, and I was so appreciative that all of that happened, so that it was very clear. And I think sometimes people say, well, I'm just going to let my heirs worry about it. And I feel like that is a very selfish way to view it. Even just to have something basic. And we'll talk about terminology here in a little bit, but it leads to my question is, how do you recommend an individual, a couple, or a family have that conversation about their estate plans? Do you recommend it around certain events? And when should people start to consider an estate plan?
Truthfully, anyone who's over the age of 18 should have an advance directive or the appointment of a healthcare representative. And I say that because this is what happens. Our kids go off to college and they're 18 and they're in a car accident in the city where they're going to school. And mom and dad are desperately trying to get information from the doctors. And the doctors say, we're not authorized to talk to you because we don't have a health representative appointment for you. So I highly, and that sounds a little weird. You don't normally talk to your 18-year-old, but truthfully, it's something that I would recommend that parents ask their children to sign when they're going off to school, even if they're not doing anything else. Now, many people don't do estate planning or think of it until they have children, which could be at 25, could be at 35. But once they have children, they may start thinking about what happens if both of us pass away and we have this young child, this toddler, this middle school child. Who's going to take care of that child? And how do we want our assets to be used to raise the child, and what's important to us in terms of, and what do we have? It's lovely if everyone has millions of dollars to do a plan, but that's not the reality. A lot of people, middle-aged people, for example, have a home with a mortgage, cars with a lease payment or a car payment, a 401k, and maybe some life insurance, possibly group term life insurance. So they don't, so they may think, well, I don't have enough to do estate planning, or, everything is tied up in my 401k or IRA. People often forget about group term life insurance, which can be substantial depending on where you live. So even if the numbers are small, if you have children, think about, there are different ways you can leave assets to take care of minors. One is a trust, which we're going to talk about, but you can also put provisions in your will about, if the funds aren't large, use them to fund a 529 plan for their education. Use them to put in a uniform transfer to minors account, which is again a way to manage the investments and use the money for them. And it doesn't require hundreds of thousands of dollars to do so. So there are things steps that people can take with smaller amounts. But again, for many couples, when they're in that stage where they're not accumulating investment assets, they've got the house, they've got the cars, they've got the 401k, but they haven't reached the stage where their income is sufficient that they can go to a broker or an investment advisor and say, start investing these assets. But life insurance is a particularly valuable asset for those in that situation, because you can use, that's cash. And that comes in and that can fund a trust, for example. And the term I use is to bring your children to an educated maturity. And frequently that is not age 18. I think most of us would agree that an 18-year-old is not responsible enough to handle large sums of money. And that large sum of money may be $10,000 or it may be $2 million. But disastrous things happen when teenagers and young adults receive a large amount of money with no controls and no strings attached.
Sure. All of the things that you've mentioned are creative ways, in my opinion, to help an individual or a couple, that they may not think about. So I think that part of your role is creatively massaging and trying to put things in order that will work for them and their situation. And every file is different. We used to say in banking that every file has its own DNA.
Yes, that's perfect.
And that's so true, I think, of estate planning, because probably no one is ever the same. And what do you find are misconceptions about wills and trusts and estate planning?
One misconception is that probate is evil. It is absolutely true that many people's estate plans include the use of a trust. And I am a huge proponent of trusts. I spent 35 years working in bank trust departments. I can see their benefits. But that being said, they're not for everybody. But people have it in their mind that the only way to have a plan that accomplishes what they want and has tax savings written into it is through a trust. That's not actually true. You can accomplish a lot of those same things through a will and having assets go through probate. Now, I still recommend to clients that they avoid probate if they can. And there are numerous mechanisms for doing that, not just having assets in a trust. But there's this baseline fear, I think, that If for some reason they don't have all of their assets structured to bypass probate, that it's going to be this horrendous, lengthy, expensive step. And that's not true. One of the things that we have is something called unsupervised administration. So when an estate is unsupervised, you have the court involved at the very beginning and the very end. You still have to petition the court to say that this will is the valid will of Ellen Deeter or Susan St. Angelo. So you submit it to the court and you say to the court, this is the person that my will names, or that, I'm named as the executor or the personal representative. And I'm going to stop there for just a moment. And those terms are used interchangeably. So many people, the word in their mind that the person who carries out the terms of the will is the executor. Or if it's a female, an executrix, because we still use a lot of Latin words in our estate planning practice going back, again, years and years and years. The more generic term and gender neutral term is personal representative. So the personal representative is the one who's submitting these documents to the court saying, please appoint me as the personal representative. That's what the will asks, and issue me what's called letters testamentary, so I can use that to go to the banks and collect the assets and do what I'm supposed to do. But once you've been appointed, you don't have to go back to the court in the meantime for everything you do. You are appointed, you do your job, you collect the assets, you just pay the debts, you distribute the assets, and then at the very end, you tell the court you're done. Now, there are times when you want a supervised estate. If there is a lot of litigation and controversy, sometimes you want to have the court's blessing as you go through the steps, but that's pretty unusual to have that. So the process, if your intent is to avoid probate, but somehow you don't get everything taken care of, don't be afraid that the process is going to be awful, because truthfully, it's not. And the second aspect to that is Indiana has something called a 45-day affidavit, also called small estate administration. If the probate assets are less than $100,000, a person can use this affidavit that says, Mary Smith died on this date, more than 45 days have elapsed, there's no estate pending, and please give me the assets to distribute to the people below according to their shares. So that, again, is, I kind of think as a little bit of a vacuum cleaner. It kind of sweeps up any assets you might have forgotten and gets them transferred to the people who are entitled to receive them.
Beautiful. That's beautiful. And that, I'm going to have some other questions, but that leads me into our next discussion, which is talking about terminology. And I think it's really important that we talk about terminology, because a lot of people hear these terms that some you've already mentioned, but they hear these terms and they get really nervous because they don't understand them. Or they think, well, I'll never have to use this, or I'll never have to know this. But I truly believe that the more we know, the more we can demystify.
Yes. I like that approach. Yes.
So we're going to demystify estate planning, and I'm going to ask you some terminology, and if you'll explain what it means, that would be great. Okay, we've talked about advanced directive. Mm-hmm. Let's talk about trust.
Okay. A trust can be created in two different ways. There is something called a testamentary trust, and that is a trust created in the will. And then you have trusts that are called living trusts or trusts under agreement. And those trusts are standalone, separate from a will. And they can be revocable or irrevocable. So the idea of a trust is you are giving your assets to the trustee, and the trustee is going to hold these assets and administer the assets according to the terms in the trust agreement. So think of the trust agreement kind of like a contract. I mean, it's not exactly that, but it basically is you saying, here's what I want the assets used for. So you might put in your trust agreement that while I'm alive and I'm competent, I am the trustee and I do whatever I want with the assets. If I happen to become incompetent prior to my death, then the successor trustee, because if I'm incompetent, I can't serve as the trustee anymore, steps in and I say, if I'm incapacitated, trustee, use my money to take care of me. That's basically it. And sometimes you may add and take care of my dependents. And then you have a section of the trust that says, when I pass away, here's what I want you to do with my assets. Some trusts are very short term and others last for generations. But the simplest form of a trust is to say that the document says who gets what. There's a little more to it, though. A very critical aspect of the trust relationship is that you're giving the trustee discretion to make decisions on your behalf. So if you pass away and your assets go into a trust for your children, you're going to put provisions in there that, first of all, say, how long does this money stay in trust? And you might say it stays in trust until my child is 50. And he gets the third at age 30 and the second third at age 40 and the rest at age 50. Now, not all of them go that long, but at its essence, you're giving the trustee the terms and guidelines for how you want the money spent. So typically a phrase that you'll see in a trust document is trustee, you may, and the word may is important because that's where the discretion comes in. You're giving the trustee the decision-making capacity to use the trust assets for the health, education, maintenance, and support of my beneficiaries. That's a very, very common term. And some people go on, some documents go on to elaborate. By education, I mean preschool, grade school, college, and postgraduate studies, as well as trade school. Some documents may take a more narrow approach and say education means college education, tuition, and books. Some of that may be driven on how much money is available. If you're administering a $10 million trust, you may have a little more flexibility in how you interpret those clauses. And you may say for health includes not only payments to healthcare providers, but also insurance, which is, critical. So the trust document is going to say, use this money for this group of beneficiaries, and then the trust terminates at some point in time when they're 50. Or it may be a generation skipping trust that takes care of your children, but continues after your children pass away and takes care of your grandchildren. So trusts are very, very flexible. And, but that being said, there's a lot of common characteristics of how they're written. Does that help at all?
You know what? It sure does. And I want to say, too, is one thing that I noticed over years in banking, that people would not get property or checking accounts, any assets retitled in the name of the trust when they had a trust agreement, a trust document. They didn't go in. And I think that's that's not always done, and people either don't know to do that or they forget to do that. And I think that's a big mistake.
I would agree with that. Many estate plans fail because of how assets are titled. And so you may have spent good money on a great document or set of documents that simply are useless. And it's not so much if they are still in the individual's name. That's kind of where the will comes in. If you have a standalone, what I refer to as a living trust or revocable trust, the idea is, just as you said, Susan, to put your assets in the trust now. That's how you avoid probate, is you go ahead and you put those assets in the trust. You still want a will. A will is, again, like the vacuum cleaner. It comes along and it says, if there are any assets that I've not already put in my trust, transfer these assets into the trust. And then again, the trust has the provisions about how the money is to be distributed. But the will doesn't act on all assets. And this is, again, kind of a critical component. Assets are owned in multiple ways, and how they are titled is absolutely key, and it's so important to let your estate planning attorney know. If all of your assets are owned jointly with rights of survivorship, your will doesn't do anything with them. So if you and I have our home and our bank accounts and our investment accounts all set up as Ellen Deeter and Susan St. Angelo, jointly with rights of survivorship, and my will says I want all my money to go to XYZ charity, and I die, my will has nothing to act on because those assets pass by survivorship to you. And so that's a huge issue in estate planning. So yes, that is a big mistake.
Before we move into, I want to define revocable and irrevocable, because those are often questions that I hear too. But when you pick a trustee besides yourself while you're alive, you are the trustee of your own trust, and you start picking people to serve in various capacities. Do you have any recommendations for those jobs?
Yes. Now, first of all, it needs to be someone who is smart and who has good attention to detail and good record keeping skills. Those are key attributes for a trustee. So, some people pick a trustee because it's my spouse, it's my oldest child. Therefore, the honor goes to my oldest child. Being a trustee is work. It's a job. And it is a responsibility. And the thing about a trust is, once you accept the appointment as trustee, you are obligated to carry out the terms. You have duties and responsibilities not only that are in the trust document, but also under Indiana law and federal law. So you have an obligation to understand and follow all of those rules and regulations. Now, you don't have to do it by yourself. So if you are an individual being named as trustee and you decide you're ready to take it on, you are permitted to hire people to help you. So you might hire an investment manager to manage the assets. Now, the ultimate responsibility is still with you as trustee. So you'll confer with your investment manager, and together you will set goals and objectives for how these assets are invested. And you might hire an attorney to advise you in the administration of the trust. So the estate plan is done and the estate probate, et cetera, is done, but you might still want to keep your attorney's number close, because if you have a question on the administration of this trust, or if you just don't understand a provision, call the attorney. Some people make the decision to use a professional trustee. And that can be, for example, a bank that has a trust department, or a standalone trust company, or an individual who serves in that role regularly, so they have the professional expertise. So sometimes that's a person who has just decided, again, maybe they come from a bank trust department background, and so they know all of the things they're supposed to do, so they set up shop. Or it could be an attorney, or a CPA. But what you truly want is, again, someone who is trustworthy, who's honest, because the reality is the trustee has great power over those assets. And you want them to be accountable to the beneficiaries and not steal money from the trust or borrow money from the trust.
Which I have seen. I have seen it, and how sad it is for the beneficiaries. Really sad. So, explain the difference between a revocable and an irrevocable trust, please.
Okay. A revocable trust is a trust that is the trust under agreement, not the trust under your will. The reason I say that is the trust set up under your will doesn't take effect until you die. So once you die, now it's in place, and typically it's going to be irrevocable. I mean, it will still have a point in time where it terminates, but while you're living, you can amend your will. But typically what we think of as a revocable trust is a separate trust document, where the document says, this is the Ellen Deeter Trust. Ellen Deeter is the trustee. And while Ellen Deeter is alive and competent, she can revoke, amend this trust at any point in time. She can put assets into it. She can take all the assets out of it. Then it usually becomes irrevocable at the moment Ellen Deeter dies. So it morphs from a revocable trust to an irrevocable trust, but not until the person who has created it, who's sometimes called a settlor, sometimes called a grantor. We have all these terms we use, sometimes called a trust maker, but essentially it's the person who's setting the trust up. So usually that standalone trust becomes irrevocable, again, if I'm the settlor when I die. Now, sometimes I want to create a trust and put money in it, and by doing so, I relinquish all of my interests in the trust. And once that money or assets are in there, I can't change my mind. It is irrevocable from the beginning. These trusts are often used in large estates for tax planning. So anyway, does that kind of help?
It does.
Okay.
It very much does. And it made me think, do you ever see people who get miffed with their relatives and they call you and they say, I want to make a change to my estate, and you're like, calm down. Is this really what you want to do?
Let's talk about it.
Yeah, let's talk about it first before you make any major changes. And what's that document called if you do make a change to one of those documents?
If you're making a change to your will, it's called a codicil. If you're making a change to your trust, it's called an amendment.
Mm-hmm. Good. Yeah, I'm sure you have some stories, but I won't go into those right now. But So, can you explain what a living will is?
A living will is the document that is used that has your end of life decisions about nutrition and hydration. So again, up until several years ago, we typically had two documents: the appointment of a healthcare representative, also often called a medical power of attorney, and the living will. With the advance directive, you can combine that, but you can still have a standalone living will. But that's the document that says, when I'm in a persistent vegetative state and my doctor says I am not going to recover, I want no artificial nutrition and hydration. I do want artificial nutrition and hydration, or I'm not making a decision and my healthcare person has to make it for me, which is a big burden, truthfully, to put on someone. And I understand people being reluctant to say one or the other. But but again, you need to have if you're going to do that, have conversations with the person who's going to make the decision.
Well, that's what it is too, is about communication. And I think about myself and who I would name as a medical rep. And would I pick someone who is local in case something happens to me and has to react quickly? Do I pick someone who knows me really well, knows my health, knows what I want, or I explain what I want? I mean, do you have any thoughts on that, on how to choose someone?
I do. So, and there are pros and cons to both. If that, ideally you have a person who's close and local who, knows you well enough to, but the reality is, in our world, kids move away, best friends move away. And so the person who knows best and who will carry out your wishes, might not be here in town. When I do an appointment of a healthcare representative in my advance directive, for example, I include not only the person's name, but their current address and their telephone number. Yes. So the communications, even though it may not be ideal, can take place over the phone or email. So maybe the call goes out to my best friend who lives in San Jose, and they're going to be getting on a plane to come out because it's a dire situation. But in the meantime, they're having all those conversations with the doctors.
So is that person someone, it could be, and it could be someone else that you would name in your passing that would take care of your funeral arrangements? Because you could ideally have someone, who is single or that says, hey, I want my nieces and nephews to take care of my funeral, and you want certain things to occur at that funeral.
There are two ways of doing that. One is you can name someone in your documents to make those decisions for you. You can also do a separate standalone funeral declaration of wishes, and that can be as expansive or narrow as you want. At a minimum, you might say, I want to be buried or cremated, pick one. And I have a plot at Crown Hill, and that's where I want to be buried. Others go into a lot more detail. They'll say, I want to be buried. I want the services held at Christ Church Cathedral. I want this psalm read. I want these people to be the readers. And I want my headstone to say ABC. And they are very, very specific in their planning. I will tell you, when my mother passed away, she was very specific in her planning. She said where she wanted a memorial service to be held And she did have very specific readings and hymns that she wanted at her service. And I will tell you, it made it so much easier for us. I'm one of 5 children. And, it's hard to say if we would have agreed on, how to handle things at her passing.
True. And I'm glad to hear that from you as an estate attorney too, because I think you're in a state of grief at that time, and you make some decisions based on emotion, and it's nice when things are already clearly made for you, and so I think that's just a really good peace of mind, and a nice love letter to your loved ones.
Yes. And you can take it one step further and actually prepay your funeral. And so, that can be very beneficial as well.
Years ago, it was probably 20 years ago, I walked into a funeral home and I asked to meet someone about prearranging my funeral. And they looked at me and said, one, you're either a shopper, you're shopping us, like a secret shopper, or two, do you have a terminal illness? Because they couldn't believe I was being so proactive. And I go, no, I'm seriously, I just got my will done, and I thought I wanted to take care of it then. Now I didn't, but it was a funny story, and I will never forget it. But I was being proactive. So what can I say? We've talked about executrix, and personal rep. Is there anything more you'd like to say on those terms?
No, really. Just again, think of them as being interchangeable. But most, well, again, sometimes when I'm talking to someone, I'll say, who do you want to be your executor? Because people associate that word with wills. And if I use the term personal representative, they may not understand what I'm asking. So I then explain that, personal representative is the newer term, but.
Sure. So the term beneficiary.
Beneficiary is the person who's going to receive your assets. So you can have a beneficiary of a will if your assets are going through the probate process, or the beneficiary of a trust. So the idea is the beneficiary is the person who is going to benefit from, receive the assets.
Right. TOD and POD.
Okay. Those are shortcuts. So TOD means transfer on death, and POD means payable on death. This terminology refers to setting up an account or real estate where you say, at my death, transfer it or pay it to the individuals named. Many people use these designations as an estate planning tool, as again a way to avoid probate without having to use a trust. There are pros and cons to using them. So that's true really with any technique that we use in estate planning. They may work for one person and not another. One of my concerns that sometimes comes up with having all of your assets in a TOD or POD designation is then there's no one person who has authority. And so I have all my assets set up that way and I die. Who's going to pay for my funeral if I don't have it prepaid? Who's going to run around to all the beneficiaries and say, okay, we want to have Ellen's funeral here and we've picked this casket, etc. And the cost is $10,000. Each of you 5 people have to chip in $2,000. And one of them says, no, I'm not going to do that. Or one beneficiary takes it upon themselves to prepay the whole thing because, funeral homes are not going to proceed until they get paid. And then they go to the other beneficiary seeking reimbursement and nobody will. So they're on the hook. If those assets had passed under the will would have said, this person is the executor. They're to handle all of this and they're to pay my debts and expenses. So they pay the funeral bill before the beneficiaries get their money. So there are drawbacks. The more harmonious I think the family unit is, or the fewer people involved. So if I have 2 children and I'm doing everything half and half, it might make sense. But if I've got 10 beneficiaries, it might make more sense to let it run through the estate, even though it's probate, and have one central figure kind of in charge of things until it's time to distribute the assets. So again, they're very useful tools. I'm not slamming them at all, but they have a use, but they're not for everybody.
Sure. Yeah, I totally agree with that. Prenuptial agreement.
A prenuptial agreement is an agreement where 2 people who are about to get married set up strings on what happens to the assets in the event of a divorce or death. It is often done with a second marriage. Not that it doesn't happen with first marriages, and especially if one of the parties in the first marriage has a lot of assets, their parents are wealthy, they've set up a lot of assets and done a lot of gifting to one of the beneficiaries, and the concern is the non-wealthy spouse is going to inherit part of the family business or this money in the event that the wealthy spouse dies or there's a divorce involved. So the prenuptial agreement sets all that out. Again, it's often used in second marriages where each spouse brings to the table assets and they each have children from their first marriage. And the idea is what's mine is mine, what's yours is yours. When I die, my assets go to my children. And when you die, your assets go to your children. And I am waiving any interest that I have by law in your estate. And what that means is Indiana law, and this is true of all states, have minimum amounts that go to a spouse in the event there's no will, or in the event the will leaves everything to someone other than the spouse. And so that's called either the spouse's intestate share. Intestate means without a will. So if you die intestate, you've died without a will. If you die testate, you have a will. And kind of think back to the terms of the person signing the will. It's either a testator, a guy, or a testatrix, a gal. Again, going back to our Latin. So by having this agreement in place, you can lock that in. And it's a binding contract, essentially. And it may say, if we divorce in the first 5 years of our marriage, then you get nothing. If you were married at the time I die, then you get something. They're very unique depending on the facts and circumstances. The key is when you're entering into an agreement like this, a contract, you have to have what's called consideration. It has to be a trade, a bargain, and I'm giving something up in exchange for receiving something. Well, if you have a prenuptial agreement, also called a premarital agreement, by law, the upcoming marriage is the consideration. And that's what makes the agreement valid. Now, there's other provisions. You have to have full disclosure of all of your assets. No trying to hide assets and, and that sort of thing. And so sometimes people want to do a post-nuptial agreement. Okay. They're harder to do. And the reason for that is usually the consideration for an agreement of this sort is the marriage itself. Well, if you're already married, what's the consideration? There have been some cases in Indiana law, not a lot, where the parties were going to divorce. They've separated. They're on the path to the divorce, and they decide they want to try to reconcile. And so the consideration is the fact that they're going to stay married instead of divorcing. So it can be done. I don't see a lot. Well, I don't, really get into a lot of premarital and postmarital agreements, but ideally, if you want to have those kinds of strings attached to make sure that your spouse doesn't get to the assets you want to leave to your children from your first marriage or the assets that your parents have given you, then you do it before the marriage. And don't spring it on your soon-to-be spouse the day before the wedding.
True. So I had a question about that, and now I forgot it. I know what it was. It wasn't really a question. It was more of a comment. I've been reading that more young people are getting prenuptial agreements, and I don't know if there's something with these younger generations, they're more educated or they've acquired more assets at a younger age, maybe Bitcoin, maybe things like that. Do you have any thoughts on that?
I think perhaps a lot of it is due to having divorced parents and seeing the ugliness that comes about in splitting assets and the fights that occur over that. So my guess is that may play a big role in it. The awareness of what happens when a married couple splits.
Interesting. I know you mentioned probate, but is there anything you want to talk about probate? Anything else?
Again, a probate means to prove. So when you go through probate, what you're doing is you're proving that this is the last will and testament of, say, Ellen Deeter or Susan St. Angelo. And the process of signing a will, I do want to touch on this. So most of the documents that we've talked about are documents that are notarized. Your power of attorney is notarized. And again, the power of attorney covers financial decisions. Your advance directive or your appointment of a healthcare representative is notarized. You don't have to have your trust notarized. I usually do, but you don't have to. A will, on the other hand, has to be witnessed. So you go through a formal little process when you're signing a will. And you have to have two witnesses who are not people who are going to take under the will. They have to be disinterested people. And you all have to be together when you sign. So what happens is the witnesses are declaring, I saw Susan St. Angelo sign her will. She signed in our presence. We watched her sign. We, the witnesses, watched each other sign. She was of sound mind and was not under any duress or pressure that we could tell to sign the will, and she was over the age of 18. Now, in the old days, when you went to probate a will, you had to find one of the witnesses who could come down to court. And in the old days, when you opened an estate, you gathered up the original will. You gathered all the documents that the attorney prepared. They're called pleadings. And you, the attorney and the proposed executor, went down to the courthouse in front of the judge and said, gave all the paperwork. And you took the witness. And again, the witness said, yes, I saw Susan sign her will, and the other witness and I, et cetera, et cetera, et cetera. Well, you know what? People move, witnesses move, witnesses pass away. And so now you can do that step at the same time you sign the will. So it's called a self-proving affidavit. So the first part of the will is, this is my last will and testament. I give my property to, and I sign as the testatrix in my case. And then my two witnesses sign. And then we sign a second document that's attached to the will. And it says, we signed this will, Ellen signed this will on this date, and she appeared to be of sound mind, not under duress. We watched each other sign, etc. And that then is attached to the will. So when you go down to probate the will, you don't have to find the witnesses. You've done it in advance. So that makes it much easier. Secondly, you don't have to go down to the courthouse anymore. All of our filings to open an estate are done electronically. So we e-file. So you have email, we e-file the documents to open the estate, which is another one of the things that streamlines the process.
Sure. So was this old process where you had to go down to the courthouse? Did you go down and horse and buggy, or how long was this changed? My goodness.
Well, I'm not sure when. Well, going down to the courthouse up until the last 5-10 years, you went to the courthouse with the documents. E-filing is new. Now you could, so again, doing it all electronically is new. And there are pros and cons, I will say. The benefit of having to go down to the courthouse is you got to know the courthouse staff. You knew the clerks, and you knew what we call the commissioners, who also, you can appoint commissioners when you're a judge, and they can also hear cases and make decisions. So you got to know people. And now with filing everything electronically, you may practice for decades and never set foot in the courthouse. It's very convenient. But you lose a little bit of the personal touch.
Oh, absolutely. So, I don't see estate planning as trendy. So pardon my question, but are there any trends you're seeing with estate planning, or anything that's changed? Like you've said, obviously the electronic part has become more streamlined, whatever. But is there anything else people are doing now in estate planning?
Well, one of the big questions we had revolves around taxes. And so when I first got in the business, when I was still in law school, the federal estate tax exemption was $60,000. So if you had assets, and it didn't matter if they were probate assets, it was all of your assets, your life insurance, your pension, your 401k, your house, etc. If that was over $60,000, your estate owed federal estate tax. An estate tax is a transfer tax. It's a tax on giving away your assets at death. And over the years, that number has increased. And so a lot of our planning for many years has revolved around structuring our estate plan to take advantage of and minimize federal estate tax. Well, the estate tax exemption right now is about $14 million per person. So if I'm married, between the two of us, we can give away $28 million and not owe federal estate tax. So the tax planning aspect of the estate tax, the tax aspect of estate planning has been minimized. And so that's one of the things we're seeing. I don't really see it, though, reducing the use of trusts. Some people think that, well, we don't have to do all these trusts in order to take advantage of estate planning, but there's so much more to setting up a trust for my beneficiaries than taxes. It goes back to our prior discussion. How do you want your money and assets used for your beneficiaries? To raise them if they're children, to, again, help them make wise decisions with investments and prepare them for the day that the trust ends and they get this sum of money. So part of the role of the trustee, I think, can be teaching your beneficiaries, educating them on good investment decisions and good spending decisions.
Yeah, absolutely. When we started the conversation, we were talking about how an 18-year-old going off to college should have an advance directive, and young parents, or when you become a parent, having an estate plan. But there's other times that people should set them up or change them. Can you give a few more examples?
I do highly recommend that an individual have, again, an advance directive, probably a power of attorney, and a basic will, if nothing else. And then when you start factoring in larger sums of assets and children and those sorts of things, really think about the use of a trust, whether the trust is created in the will or is this separate standalone trust. As far as reviewing, major life events should trigger a review of your estate planning documents. And major tax law changes should trigger a review of your estate planning documents. This $14 million exemption we have, well, it was scheduled to go away the end of this year. And so that got repealed. So now it's still in place, but it could be changed by Congress at any point in time. So if Congress meets, 10 years down the road and says, oh, the exemption is going to go back to $1 million, well, that would significantly change estate plans for many people who were in the $5 to $6 million range, who basically weren't worried about taxes because, well, $5 to $6 million is a whole lot less than 14. Not my problem. A death of a spouse. Now, you don't necessarily have to change the documents. And the reason is this. Usually the documents in their language say, I give it all to my spouse. But if my spouse dies before me, then I give it to my children. So your estate planning documents usually have built into them contingencies. And that's part of what the attorney helps people with. And sometimes I feel like, I'm talking about disasters here. What if you die and all your children have also died and all of your grandchildren? Who do you want your property to go to? And do you want it to go to charity, kind of thing? And it's a little awkward to have those kinds of scenarios because it's very unlikely that when I die, I'm not going to have any direct descendants, but, I might not. Or if I'm single, I might not have children. But so again, you don't necessarily have to change the document at that point in time, but it's still worth a review because other life circumstances may have happened. When you create your document and your children are young, you don't know necessarily what their issues might be. And you might discover as they become young adults, one of them has schizophrenia. Or one of them is just one of those can't hold a job, still trying to find his or her way in life. and you're worried about that child. And so your prior will said, I give everything outright, each child a third, a third, a third. Now you might want to change it and say the third for this child stays in trust. And the trustee uses the money to pay their rent, to pay their medical insurance, and provide them an allowance in order to preserve the assets. So death, divorce, tax law changes, or, you don't like the beneficiaries anymore. I hate to say it, but, sometimes you see the behavior of nieces and nephews or cousins or siblings and say, I don't condone that. And I would rather my money go elsewhere.
Right. That's right. Well, you can't take it with you.
That's true.
So one more question. What should people look for who are listening and watching? What should people look for when they're choosing an estate attorney?
Well, certainly I would say experience. So there are some designations that attorneys can have. But that in and of itself, if an attorney doesn't have those, doesn't necessarily mean they're not very capable. One is Indiana allows certain attorneys to be considered estate planning specialists. It used to be that you could not claim that you were an expert unless you were a patent lawyer or a maritime lawyer. And they have their own separate bar exams. The bar exam is the test that you take in order to be licensed to be an attorney. Well, a number of years ago, they came up with the idea of having these specialty designations for certain types of law, and estate planning was one of them. So in order to become a specialist, you have to have been in practice for a certain number of years, and you have to take a test. I'm not a specialist. And the reason for that is when they did the exam, I worked in banking. I've worked with trusts and estates since 1979.
Wow.
Yeah. So a lot of years. I've earned all my gray hair. And but the fact that somebody is a specialist is something that you could say, okay, they should have a level of capability. Another is ACTEC. ACTEC is the American College of Trust and Estate Council. It's national. And again, you have to apply, you have to be recommended, and have written a certain number of documents. I'm not ACTEC. And again, when I think about it is, I spent 35 years of my career working in bank trust departments, not in private practice. So did I gain a lot of experience and have a lot of knowledge? Yes. Do I necessarily qualify for some of these designations? No, because I wasn't in private practice in those years. But an ACTEC designation is a very good designation. And sometimes it's a matter of what kind of complexity do you have in your estate? The attorney that you want for a $10 million, $20 million, $30 million estate, or an estate that has closely held businesses and partnerships and LLCs, may be very different from the attorney that you use where you have a house, an investment account, a 401k, but you don't have these closely held businesses, and your net worth is anywhere from $50,000 to, $5 million. So part of it is, one, ask for recommendations from friends. That's a clue. But again, these designations can be very helpful. You might want to see if you can find out how much teaching the attorneys do. Are they regularly speaking at seminars on estate planning and taxation and trusts? Now, again, some people know how to do it, but they're terrible speakers, and you can have good, but in general, that's somewhat, if someone is doing that, they're pretty invested in that area of law.
And they're up to date.
Yes. The other thing is both Indianapolis and Indiana Bar Association. So there's the Indianapolis Bar Association and there's the Indiana State Bar Association. Both of those bar associations have sections for different areas of law. So, for example, I belong to the probate, trust, and real property section of the State Bar Association, and I belong to the estate planning and administration section of the Indianapolis Bar Association, and I'm a member of the Estate Planning Council of Indianapolis. So some of those types of things can give you an indication, again, of.
Sure. Good. Well, that was informative. I really did not know about all those other things. I just assume, and some people get an estate attorney and what's the other attorney for older people, for older
elder law. Okay, you know what? I'm so glad you said that, Susan, because they're not necessarily the same. I mean, many of my clients are elderly, but elder law, an attorney who practices elder law usually has a subset of their practice where they do Medicaid planning. And so Medicaid planning is different from traditional estate planning. It has its own separate rules. And so Medicaid planning, one is done for, it can be done for younger people who have had a traumatic brain injury, or you're planning for a child who has Down syndrome. And what you want to do with Medicaid planning, whether it's for an elderly person who's worried about nursing home expenses, or for that younger person who, again, has these very significant cognitive issues, is that you want to qualify these beneficiaries for government benefits. And so if you're going to qualify for Medicaid, for health insurance, or for Social Security, disability, there's different criteria, and you can't have too many assets. So part of the technique is giving away your money and living beyond what we call the look back period. So if I give away all my money to you today, and tomorrow I'm hit by the proverbial Mack truck, and now I'm in a skilled nursing facility, Medicaid is not going to cover that, because they're going to say, you gave away your money within the last 5 years. In fact, it was yesterday. And so you have to wait 5 years until you qualify for benefits. But there are other techniques involved, but it is a subset. And so I would say typically if someone is saying they're an elder law attorney, they probably are also doing Medicaid kinds of planning in addition to typical wills and trusts.
Sure. Good to know that, and good explanation. So, Ellen, what is your SOS? What's that simple step or two that our listeners and viewers can take away today, in addition to calling you? But what one or two things should they consider?
First of all, think about these decisions ahead of time. It's not fun to think about what happens when you're ready to die. It's not fun. It's not a fun thing to think about, but you need to give it consideration. So you need one to get a sense of what it is you own, and kind of get all that written down. And again, not just how much is in the account, but think about how it's titled. Again, is it owned jointly with rights of survivorship? Does it have a transfer on death designation? Is it a 401k or an IRA? If you tell me that you have $500,000 in this account, but you don't tell me it's an IRA, whoa, that's a huge issue because of all the separate rules for IRAs. And so if it's just a straight $500,000 investment account, I may say, let's put that in a trust for your kids. If it's an IRA, we can put it in trust. It has some challenges, but it has to be done differently. Or again, you may not want to put it in trust at all and simply leave it to those beneficiaries. So knowing what you have, but knowing how it's titled and what kind of an account is really critical information. Secondly, and you know what? I have to plug in my battery really quick here. I'll just take a minute. Okay, plugged in. Again, think about the people you want to take care of. And then think about the people you want to have take care of you. And who ultimately you trust without reservation. I think those are very challenging things to think about or to do. But I think it's very important.
I do too. And if I could add one more thing that I've suggested to people is once they have their estate plan and they've got their folder, their binder, put it somewhere where people know where to find it in case of an emergency. It's safe and protected from fire and the elements. And, if you have to provide in a sealed envelope a copy of your will and trust documents and your healthcare directives and your funeral directives and all those documents to that person who's going to take over that responsibility and not to be opened until, your death. I think that's really key because if something happens in a case of an emergency, I've seen this where people are frantically rushing to find out where mom's documents are because they've got to get to the hospital or the child's been injured and they need to get what they need. So I think that's also important.
I would agree. And one thing you can do, and I typically do for my clients if they are at all computer savvy, is we sign all the documents. I keep a copy of each one. My client gets two, although they only get one original will and then they get a copy of the will. But after they're all signed, my copies I scan and then I email them to my clients as well, which makes them easier to retrieve frequently. It depends on how organized your client is. And some people have stacks and piles throughout the house, and some have file cabinets with everything very neatly labeled. It just depends on the person. But if they are using email, I can send them to them via email, which also, when they make the decision, and it may not be right now, they can easily send those documents on to, say, the person they've named, as their health care or their power of attorney. They may be reluctant to do it right now, particularly with the will and trust. But that makes it also easier to get them in the hands of someone quickly.
Good point. Ellen, we've covered a lot, but is there anything else that you'd like to talk about that we didn't mention?
Kind of like Nike, just do it. Again, it's everybody, many clients delay. I cannot tell you how many people who've contacted me. They want to set a meeting. We have the meeting, and then they get the drafts, and then it's like, I follow up, and they just can't do that final step. Or we're trying to set the appointment. And again, I know it's not fun. Find an attorney, if you can, who doesn't talk down to you. This is very personal stuff, particularly if there are family issues that are hard to talk about. A child who has a drug addiction, a child who's gone through bankruptcy, or even just disclosing what you own. We're brought up not to talk about our money or our income. Well, I, as the attorney, am asking you for what you own. And I had a client say to me, do I really have to give you all that information? I'm kind of uncomfortable. And I said, it's kind of like going to the doctor without telling him what medications you're on or what your symptoms are. I can't prescribe an estate plan for you unless I know what it is you have. So if I just write a will that says I give everything to my children, I'm doing you a disservice. It might be better than nothing, but I'm uncomfortable with it, truthfully. And so you need to be transparent about those things, even if it's very hard for you. So, feel free, if someone wants to make an appointment with me as a prelim to kind of interview me and see if we're a good fit, I'm okay with that. Maybe you decide that this other attorney you like better. I'm not going to be offended. Because part of finding the right attorney is part of, making a connection. And so, you may have to talk to a couple of people before you make that final decision.
We always make a recommendation, at least we did in banking, of at least 2 or 3 options for people to talk to on different things. So, because people's personalities, the situations are different. Some might want a boutique firm, some might want a larger firm like a CPA or a certain type of an attorney. You just might have a better fit with one person. You click with that person. You feel really comfortable with them. And I think that's so important. On this podcast, SOS for Your Life, Emergency Wisdom for Everyday Life, I talk a lot about how small steps can make big changes. And I think you've nailed it. It's just take that step, just do it. And I hope that people who have listened or watched this podcast realize, you can do it. There's a lot going on, but you pick the right person that has the knowledge that can walk with you. I think it becomes such a big peace of mind, not only for yourself, but for your relatives.
Yes, I would agree.
And I truly believe this is part of our financial health too.
Yes, absolutely. Absolutely.
Because, there's nothing worse than having something left and you think I didn't do what I either wanted to do or said I would do. So, Ellen, how can people reach you?
Well, a great way is email. And my email address is my first initial, E for Ellen, and then Deeter, D as in David, E, T as in Tom, ER, at DeeterLaw, all one word, .com. Now, I have a webpage, but it has not been updated in many years because when I started it, a long time ago, and then I when I was on my own, and then life happens. So then I went with a firm, and so it's deeterlaw.com. As I said, it's a little outdated. It's on the list of things to do. Also, my phone number is 317 I'm still getting used to it. 730, had to look it up here, 5706. So 317-730-5706.
Perfect. Well, Ellen, it's always a pleasure to see you, and thank you for being on SOS for Your Life, Emergency Wisdom for Everyday Life. I'm so pleased that you were able to join me today and to share your wisdom and your knowledge on estate planning. And I hope everyone will tune in and listen and watch and learn something new.
Well, I appreciate you asking me very much, and it's wonderful to see you again as well.
Absolutely. Thank you. Well, friends, sadly, that's all the time we have today. Thank you for listening and watching SOS for Your Life, Emergency Wisdom for Everyday Life. And thank you, Ellen, for joining me today. It was so nice to see you. And I think this episode really can be summarized as saying it was an education. Estate planning is not easy. It's not fun, but you can learn something from this episode, whether it's the need to take the next step and start looking for an estate attorney, or to start gathering your documents, what assets you have, what your wishes would be for those you love, and what you'd like to see happen at your passing. I think Ellen has the knowledge and the skills and the background that she makes everything that seems difficult much easier to understand and absorb. So I really do thank Ellen for being on this episode and talking about our financial health. So a quick reminder on how you can support this website or this podcast. You can like, share, and subscribe. You can follow me on social media on Facebook, Susan St. Angelo Coaching LLC, LinkedIn, Susan St. Angelo, Instagram, St. Angelo Susan. You can send me an email at susan@creatingnewjoy.com if you have a question, or if you'd like to be added to my weekly email newsletter. It has a lot of good, healthy tips, and it's short and sweet. So I hope that you will continue to follow me and enjoy this process we're all on. So thank you so much. Take care, and I hope our paths cross again.